Okay, when does a contract have to be in writing to be enforceable? Or another way of saying that is, what is the statute of frauds and when does that apply? So basically, some contracts are enforceable without being reduced to writing. That is, they can be verbal and they can be completely enforceable. Other contracts generally have to be in writing in order to be enforceable, and that rule is known as the statute of frauds. Okay, so what's the reason for this? As the name implies, there has to be sufficient writing between the parties that identifies the key terms of the contract, sufficient to identify the goods being exchanged, the parties to the contract, so that fraud cannot be committed in the relationship. That's the general rule. What type of contracts have to be in writing to be enforceable? There are a number of them. The first and most common is land or real estate. Another situation would be a promise to pay the debt of somebody else. So, say for example, you had to have a cosigner, perhaps a parent or a friend or family member cosign. That is making a promise to pay the debts of another. And again, that has to be in writing. Okay? Yet another example is a contract that is not capable of being performed less than 12 months. The key to that is to understand there has to be a strict impossibility of performing it within a 12-month period. And another, and perhaps the most commonly known statute of frauds rule, is the sale of goods for a value of $500 or more has to be in writing to be enforceable. Okay? That's a good, a piece of personal property of $500 value or more. Any contract for the sale or exchange of that good has to be in writing to be enforceable. Okay? Now, there are exceptions to the statute of fraud, and we'll talk about those in a different video. But generally, these are the areas of law that require the contract to be in writing. Other examples that vary from state to state would be, for example, insurance contracts. Generally, they are required to be in writing as well.